Welcome to the debrief, everybody. Glad you're with us this evening. Convicted rapist Harvey Weinstein is apparently not enjoying his time in a New York hospital. Weinstein's publicist, Judah Engelmeyer, tells Reuters that Weinstein's time in a medical unit where he remains under guard is getting to him. Weinstein complained of chest pain after his conviction last week, and rather than going to Rikers Island, the jail in New York, he went to a prison wing at New York's Bellevue Hospital. When no one's there, he said he's just staring at the four walls. He can go stir crazy just staring at the emptiness, his publicist Judah Engelmeyer said. He doesn't like being left alone. Manhattan DA Cy Vance faced questions this weekend on the broadcast Axios on HBO as to why he did not prosecute Weinstein the first time he had the chance to do so. Some have said Vance should resign despite last week's successful prosecution.
What has changed for you in terms of how you view these sex crimes cases between 2015 and now?
I think I have had an evolution of my understanding of the dynamics of sexual assaults. And quite honestly, I think in the aftermath of the Me Too movement in October 2017, society has evolved. Sex crimes are among our most difficult cases because they typically involve just two people who were in a room with very different stories. And I think this case has helped elevate the voice of the she in the he said, she said.
Let's jump in with analysis right now. With me are three guests. Joseph Scott Morgan is a forensic examiner who teaches at Jacksonville State University in Alabama. Attorneys Michael Bryant and Elizabeth Crotty are with me here in New York. So, Elizabeth, we are hearing from the publicist that Weinstein's not happy with his incarceration. Is he supposed to be happy with where he is?
No, he's not supposed to be happy, and nobody is ever happy. I mean, I think he was remanded to the custody of Department of Corrections. They put him in a hospital because his papers were marked for medical attention. If he no longer needs that medical attention, he will get shipped over to Rikers Island. I think jail is a place no one likes to be there, Harvey Weinstein or not. It's not a place anyone really wants to go. And the fact that you're staring at the walls, well, that's what jail is. So that's where
in other words, no love for Harvey Weinstein here.
No.
Okay, so let me ask about this. Michael Bryant, your reaction to Cy Vance's comments that his views have resulted in an evolution of his thought process. Does that get him off the hook for the criticism of not going after Weinstein sooner?
A little too little too late. I mean, let's face it, he knows he should have done this back in 2015. He did not, and now what's he going to say? What's he going to say except that he had to have some metamorphosis, some reason that now it's okay. Back then, no, it wasn't appropriate.
I mean, what was it, though? The strength in numbers, Michael, that resulted in this evolution, perhaps?
I think, he's a DA. I think it's public sentiment. He's always concerned about what the electorate might think, and back then it wasn't as big a deal. It couldn't have gotten away with it now.
Joseph Scott Morgan, your thoughts on this one?
Well, if he's dissatisfied with the accommodations at Bellevue, then he's got a trip in his future. He's going to go out to sunny Southern California. And we'll do this whole thing again. And that's going to have everybody watching this. Look, his attorneys have prepared him poorly. If he thought that this was going to be anything other than what it is, he is a convicted sex criminal now. He is to be remanded over to the state, and they're in charge of him. He better get used to this idea very quickly.
Yeah, exactly. I mean, we've heard that he is working with a prison consultant. We spoke with a different prison consultant here on the Law&Crime Network who said, look, he needs to be put into the right mental state for what he's going to face here. Is he in denial, Joseph?
Yeah, it would seem that he is. I don't know what he thought prison was going to be like. Who knows? This guy's dealt in fantasy his entire adult life. And now, I don't know. It would seem that things have come home to roost at this point because he's just like all the rest of us. He's descended from Mount Olympus. He is now here among us, all of us. And he's going to have to pay a heavy price for what he's done.
Yeah, I mean, prison is not like a movie because the board doesn't hit cut and then everybody goes back to the trailer at the end of it. I mean, they go back to their cells here in this case. Let's move on. We've got a lot to talk about tonight on the debrief. The husband of the Idaho woman due to be extradited this week says 2 missing children are safe, but He declined to elaborate when asked about those children by ABC News. Mother Lori Vallow is accused of felony charges. Prosecutors say she deserted her 2 children and failed to support them. She's due to be transported away from Hawaii, where she was arrested this Wednesday, to Idaho. A hearing tomorrow in Connecticut will likely wipe away the criminal case against dead murder defendant Fotis Dulos. Dulos died by suicide, and the hearing will determine whether his criminal case should be formally dismissed. Dulos' attorney, Norm Pattis, wants the case kept alive so that Dulos can be tried posthumously in an attempt to clear his name, and that is unlikely. A jury is about to get the case of a Wisconsin father accused of shooting and killing his own son after a night of heavy drinking. 44-year-old Kayle Fleischauer is being tried a second time for a second-degree reckless homicide. 19-year-old Chase died from a gunshot wound to the head. Prosecutors blame the father, but the father says Chase accidentally shot himself. The jury in the first case started conducting its own experiments to test the state's evidence, namely why the pistol wound up so far away from Chase Fleischauer's body when the gunshot rang out. The jury, of course, is not allowed to do its own experiments. That's the state's burden of proof, and that's why the case is being tried a second time. Testimony surrounded medical professionals during the last couple of days in the defense case. Here, an emergency doctor faced objections from the state as he tried to describe whether Chase Fleischauer suffered other injuries from a beating, as the state contends, or whether they were wrestling injuries, as the defense contends.
Did you see any serious external injuries?
Objection. Relevance of seriousness.
Sustained as to form.
Can you describe to the jury the injuries that you observed?
Well, all or most of the injuries I observed appeared to be fairly superficial and minor, the kind of injuries that wouldn't typically involve any serious injury to result in a serious condition or certainly death.
And the injuries that Chase Fleischauer did have, to a reasonable degree of medical certainty, could those injuries been caused by 2 intoxicated persons wrestling on a hard floor?
Objection to the relevance of the persons intoxicated to the opinion.
Recall that the defendant's blood alcohol level was estimated at between 0.293 and 0.440 when the gun went off. The son's was 0.278 when he died. Remember, of course, the legal limit is way down at 0.08. The defense doctor said both of these people were, in his opinion, intoxicated. Again, a debate over whether there was wrestling.
If one individual had approximately a 0.278, and the other individual had a 0.19 9 hours later, would you consider those 2 individuals intoxicated?
Yes.
And if those 2 individuals were wrestling with drug, would you, in your opinion, to a reasonable degree of medical certainty, that those injuries on Chase Fleischauer's body be consistent with wrestling on a hard floor?
Objection. Foundation for the word wrestling in this witness's mind.
A neurosurgeon testified how different people handle grief differently. This was a defense attempt to explain Kayle Fleischauer's bizarre behavior when his son died.
Well, if we look back in history and talk about bereavement and grief, there's usually 5 steps. And the first step is denial. And that's where the sudden bereavement emotions enter into the picture. Then ultimately there's anger, bargaining, depression, and acceptance. And but in the denial phase, we see in the emergency room all sorts of reactions from family members. The gambit, stunned like a deer in headlights, silent, crying, laughing, just the whole gambit of emotions. And so we always are very, very cautious about that, because we have to guide the individuals who are experiencing this loss carefully.
The neurosurgeon testified about the process of bringing in a patient and how she's there when emotions are both raw and unfiltered.
we're often called before the patient even hits the door. And the reason we're called is that the EMS people are the first ones to see the patient. And they call and say, this is coming in. And so frequently I'm in the emergency room at the same time the ER doctor is.
Some of the reactions you've seen from people include laughing, correct?
Yes,
Crying, correct?
yes,
Screaming, correct?
yes,
Accusing caregivers of hurting the person, correct?
yes,
Have you also seen people demanding that you, the caregivers, do more to help the person?
frequently,
This is at the hospital, correct?
correct.
Your practice wouldn't ever cause you to actually be at the scene immediately after a shooting. Is that
No.
right?
A forensic pathologist testified for the defense about what killed Chase Fleischauer and that in his opinion, Chase Fleischauer shot himself.
In my opinion, the cause of death of Mr. Chase Fleischauer was the gunshot wound to the head with brain injury.
And would that be considered the substantial factor of his death?
It would be not only the substantial factor, in fact, it would be the only factor that caused his death. So we have a wound that's consistent with being self-inflicted. We have a decedent, Mr. Chase Fleischauer, who at the time was highly intoxicated. We have a gunshot wound that's consistent with him in that state, looking at the barrel of the gun from a fairly close distance. We have his intoxicated state in terms of his impairment that would render him more susceptible to an accidental discharge under those conditions. If you look at the prior injuries, the other injuries besides the gunshot wound, indeed they all do look to be fresh or acute. However, from a strictly medical standpoint, those fresh appearing injuries could have happened seconds before death, minutes before death, hours before death.
Dr. Arden continued his testimony by answering questions about how Chase Fleischauer may have been holding the gun.
It's my position that it is physically consistent or possible for him to hold that weapon and shoot himself from that distance in that location at that trajectory. Exactly how he's holding the weapon would not be limited to the way that you demonstrated. I do not believe that it is inconsistent with him holding it the way you were demonstrating, although he could have been holding that weapon in different ways. He could hold it in essentially backwards. He could have any one of a number of fingers, including his thumb on the trigger. So yes, there are ways in which it is entirely consistent with his 31-inch arm length receiving that gunshot wound as an accidental self-inflicted wound.
But other than that, it's physically possible. You have no other basis upon which to say that that was what happened.
Well, I disagree, sir. I think the basis of my opinion as to what happened, or really how it happened, which is manner of death, is the entirety of the response that I gave earlier.
On cross, the state asked that pathologist about how he was making his conclusions, and the judge had to shut down some of the argument.
When, if ever, in your profession prior to today, have you had to distinguish between a fight and a wrestling match?
I can't recall another specific episode in which I had to make such a distinction.
Why are you making it today?
I don't think I did.
They're the same thing, aren't they?
I didn't.
Judge, I object.
Careful
Argumentative.
careful in arguing Mr. Kaiser question.
Thank you. So today, you haven't distinguished what's been termed a wrestling match from a fight. Isn't that correct?
I haven't made any comment on this issue whatsoever. I didn't make the objection.
And during a rebuttal case, a forensic pathologist testified for the state that he believed that if Chase Fleischauer had shot himself, even accidentally, the gun would have been found closer to the victim's body.
The distance that it was reported to you the firearm was found from Chase Fleischauer's body play to a reasonable degree of medical certainty in your decision to concur in Dr. Mills's manner of death as homicide.
It was a grave concern considering the information we were provided.
And in terms of accidental or suicidal self-inflicted injuries, how, if in any way, does the distance of the firearm being found from Chase's body inform your decision about this being a homicide?
It strengthens it.
In your years of experience and years of practicing your specialty, where would you normally expect the firearm to be in a pistol death of either suicidal or accidental self-inflicted injury?
In close proximity to the body.
That medical examiner then testified about fractures in Chase Fleischauer's skull, which he said were there before Chase was shot. This evidence, again, the medical examiner said, pointed towards a criminal act, a beating, despite some cross from the defense.
What is it about the fracture lines from the gunshot that causes you to believe that there were those there that stopped at the linear fracture, but that the linear fracture did not originate at the gunshot?
Sequence.
Can you describe that for me more? What do you mean by sequence?
From the fractures, it appears the parietal fracture preceded the fractures from the gunshot wound.
And is that sequence in part informed to you by the fact that the fracture lines you were able to identify from the gunshot wound stopped at the parietal fracture?
That's what I am saying.
Question: how, if in any way, did that left parietal fracture, linear fracture, which you concurred did not originate from the gunshot, how, if in any way, did that support your concurring in Dr. Mills' opinion that this was a homicide and not a self-inflicted injury?
The answer?
You can answer.
Suggests that there was prior trauma where the fracture was there prior to the gunshot wound.
And still ahead here on the debrief, a look back at key testimony in the Fleischauer trial as state and defense experts battle out why the gun ended up some distance from the victim. That testimony is after this. Opening statements are set for this week in the murder trial of real estate heir Robert Durst. The state's theory of the case is that Durst killed his friend Susan Berman because Berman knew Durst had killed his wife Kathy Durst many years earlier. Cameras are allowed for parts of the proceeding, and the Law&Crime Network will bring you live coverage as best we are able under the court's restrictions. Let's head back now to the Kayle Fleischauer prosecution, where many of the arguments have surrounded why the gun which killed son Chase Fleischauer ended up some distance from his body. State investigators attempted to recreate the shooting at a firing range in order to determine how far away the pistol was from the victim when it was fired.
He test fired this particular weapon. These are spent shell casings from that firing.
Where did you get those shell casings from that you used in September of 2018?
They were in a drawer next to where the holster was found. These are the targets that we fired at, did the test firing.
Detective, based on that examination in September of 2018, what conclusion was reached regarding the range of fire of the pistol from Chase Flyshower in the early morning hours of April 14th of 2018?
Approximately 5 to 6 inches.
A defense firearms expert who just happens to be one of the defendant's personal friends did his own recreation of the shooting.
We started to build a fixture to better hold this firearm. Lance Fleischauer was initially involved in this, and then I took over.
And who's Lance Fleischauer?
Lance Fleischauer is Kayle's uncle. The table that is used there is approximately the height of the center island in the kitchen at Mr. Fleischauer's home. The wood flooring is similar in design, as well as the carpet that the handgun was originally found on.
Distance traveled 13 feet 6 inches.
Correct.
What condition was the pistol in after it traveled that distance?
The firearm malfunctioned and did not load or chamber another round.
Let's bring our guests in one final time tonight. Joseph Scott Morgan, I'll start with you. You must be in your glory because this was all forensics testimony at this point in the case. So who do we believe here?
Well, look, to the question of how the distance that the weapon was from the body. I worked a lot of suicide, self-inflicted gunshot wounds. It's rare that I will ever find a weapon that is a great distance away from a body relative to self-inflicted injury, unless EMTs, the police, fire department, or family member have physically moved the weapon. And that goes to our desire to be safe. If you think the person might still be alive, you're going to put as much distance between yourself and that weapon and the person actuating the trigger as possible. So this test is it's stuff and nonsense as far as I'm concerned. I think there are other reasonable explanations as to how that weapon wound up this distance away from the body.
Yeah, and the defense recreation there, Joseph, basically could have resulted in some reasonable doubt being injected into the jury, though. Yep. Maybe it was a suicide. Maybe that's how it could have happened because it's visual. I mean, it happened in the demonstration, therefore it may have happened in real life. What was your take on the testimony about the fractures in the victim's skull? Was there some other fracture that was there before the gunshot? And does that point to guilt for this defendant?
Yeah, that was one of the interesting things, Aaron. I thought, we talked about the parietal fracture, which he's talking about that this occurred prior to the gunshot wound. And my thought was this what's referred to as a gas-related injury? You can get these kind of concussive injuries where when someone is shot, you'll have kind of a radiating fracture. But, the pathologist was saying these two things are not necessarily communicating. So he came to the conclusion that the parietal fracture was not associated to the gunshot wound, that perhaps he had been beaten in somehow. I just don't have enough evidence that's put before me to talk about what kind of external injuries were there to the scalp relative to this rather substantial fracture in the parietal area as opposed to the fractures associated with a gunshot wound.
Yeah, some questions that we could stand to have a little bit more of a look at the evidence. Certainly the jury has it, though, Elizabeth. So where does the jury basically shake out on this? Does the jury, believe that the gun wound up some distance away? This was a suicide? Because, again, you've got the victim's DNA on the barrel of the gun, but nowhere else that could be determined.
Well, I think it comes down to the space between where the gun was found and the defendant's body. It kind of comes down to the whole point of, was this an accident or was this reckless? I think they're trying, the prosecution's saying the further it away.
Yeah, we got to wrap things up, Elizabeth. We'll see you back here tomorrow on The Debrief, everybody.